Good afternoon, everyone, or good morning, depending upon what time zone you're in. Thank you for taking an hour out of your day to join Breen and I to discuss audits and audit resolutions and what I think is our new world, our new virtual world. Before we get started, we have a couple of housekeeping things. First of all, slides are going to be available after the presentation. We'll be happy to send them out to you if you'd like them. CPE is available for this presentation. We have 3 polling questions, and I will be honest, the polling function in this platform is a little funky. So if the polling questions don't work right, just email us at the end and we'll make sure everything comes out okay. There is a survey at the end that is required for CPE, so please take it. We do take the results seriously. So if you have some topics that you'd like to hear us talk on, or some topics you don't want us to hear us talk on, just put those in there, please. And if you're experiencing at any point, any time, technical difficulties, some of which we can solve, some of which may be the platform that you're on, but just email us and we will try to help you out there. So with that, let's get started. Let's get started. We have clearly in today's environment, the revenue needs of both the state and local jurisdictions is kind of very acute. All you had to do is read some of the state tax publications that came out this morning, and you know that New Jersey is looking for $10 billion and New York City is looking for about $7 billion. We won't even talk about Illinois, which was in the hole before we started this. COVID-19, and we're further in the hole, obviously. I mean, what you don't have today is you don't have a lot of the transaction taxes being collected. A lot of it was deferred. There's also been sales taxes down as a result of the quarantine or the shelter-in-place orders. So I think what we are going to see, Breen and I think what we're going to see are more audits. They may be more difficult because of the need for revenue. There may be changing interpretations of things, but we're definitely living in interesting times. And so what we used to handle in person, we are no longer going to handle in person, or not for a while. We're not going to be handling them in person. And while you may have had remote audits, desk audits, you on the other side generally were not sitting in your kitchen handling those audits. So Zoom is going to be the new rule. What we're going to talk about today is on the agenda. We're going to talk about some changes that may need to be made as how you approach an audit, how you handle the audit remotely, how challenging an assessment is going to change. And I had a conversation this morning with someone that we're going to do a number of things remotely that we probably wouldn't have done remotely in the past. So the question is, when all that changes, does that change how your whole approach to it? So here's our agenda. We're going to talk about audits in general, develop an audit game plan and be responses to IDRs, and what you do with stalled audits, which we may have more of today. We'll talk about what happens after you get the assessment, the notice of assessment and the initial considerations that you have to handle with respect to that. And then talk about some resolution strategies in the current era that we're in, and maybe some non-traditional resolution strategies. So with that, we have our first polling question. I can find it here. So our first polling question is, what is your role in the audit process? I handle all the audits. I manage the audit process. I'm responsible for challenging the assessments and managing litigation. All of the above, none of the above. I guess I could have answered all of the above on that. All right. Looks like we'll give you a couple more seconds here. A couple stragglers coming in. Okay, let's end our poll and share the results. So it looks like we have most people either do all of the above. Those of you who do none of the above, you really need CPE to listen to this for an hour. Basically, it looks like everybody has some responsibility in the audit process. So at that, we are going to move on to the substantive part of all of this. So, and I'm locked up. Great. Well, the next slide should say audit game plan.
Sure, Marilyn, while you mess with that, I will just start on the next slide. So the next slide, the next section is regarding your audit game plan. And, you know, generally we know that clients and taxpayers have some sort of protocol, or you have an audit game plan already in, whether you have policies in place as to how you handle an audit, whether that be how you're going to respond to IDRs, your policies, you know, general policies in regarding what the form that the IDR, your responses are going to be. Marilyn, one more. Also, oh, sorry, that was one that was, we skipped. So yeah, let me back up a little bit more. I skipped one, but so the audit game plan. So you have when you're looking at the audit, this is just kind of a general overview. Identify the potential issues you're gonna have. If you're already in the audit, obviously you're gonna know what they're looking at, but prior to it, when you get that notice of audit, identify the issues. Also identify when we say trade-off issues, like what are the material issues that you're gonna have and what are gonna be those trade-off issues. And that comes into play sometimes, you know, when you're wanting to resolve the audit, or even further down the road when you're looking at settlement, which we'll talk about later. Having those trade-off issues, things that you're willing to give in response to, or trading off on something larger that's more material for you. And also having a game plan in that you're planning or evaluating what level you think certain things can be resolved at. And, you know, whether that's the audit, how you're going to be going about that. Are you going to be filing a refund claim? Do you think this is going to be going as far as informal conference? Could it potentially reach litigation? Something also to keep in mind is it does depend on the state, or potentially the jurisdiction. I'll use jurisdiction instead of state, because it could be at city or county level, depending on what state you're in. Your chances of resolution at a certain level can depend on the jurisdiction you're in, you know, especially if you're a taxpayer that's continually audited, if they're, you know, sending someone out at every cycle, you know, the relationship you have with the auditor, you know, whether or not, you know the issues that might be in the pipeline, and what your chances are of actually coming to an amicable resolution on those. So that's definitely something you need to keep in mind. And when you're looking at this audit game plan, issue spotting and evaluation, that's going to be the same. I mean, generally speaking, whether we're in our normal circumstances or the current environment, your overall general plan is pretty much the same, but now we have these caveats that you have to take into consideration. Things might, the resolution, the way you resolve those might change. Issues that may not have been material may become material now, but the general scope and nuts and bolts of how you evaluate your audit, how you evaluate your issues, you should really have in place. It just, the scope of those might be larger now, depending on the situation. You know, as Marilyn said, if we're dealing with a transaction tax issue or transaction tax audit, that might look entirely different than it does now. You might have newer things come into play now with statutes of limitation. Are they going to be asking you to sign waivers right away, given the fact that, you know, things are stalled right now? Have extensions been filed or have extensions been put in place at the state level? So maybe you'd be normally coming up on a filing deadline that's been extended. That might give you some extra time. That might eliminate an issue you were anticipating having. So those are some new parts that might come into play under our current circumstances.
So one of the things that, before we ever start doing a deep dive, everyone on this call has been involved in audits in some way. And what you really do need to develop is an overall game plan, and you should have that in place anyway in just normal circumstances. I mean, what's your best practices? What should they be? I mean, you've got to have a general plan. Do you automatically give waivers? Do you say there's no waivers? How do you handle waivers? On an income tax side, will you provide a 50-state apportionment schedule? I have my own opinion on that one. Do you request all IDRs in writing? Yes or no? Do you respond to all IDRs in writing? On a transaction tax side, do you have a position with respect to how you handle invoices and how you handle sampling and things like that? Will you turn over reserve schedules? I have my own opinion on that as well. What do you do with proprietary type information? You should start out with those types of, that should just be a general best practice. You should have that in your pocket at all times, and then work off of that as to what Breen has been talking about with respect to specific audits. The key is in all of this is that you have to evaluate your strengths and your weaknesses with respect to the issues. And under the current, Breen said, under the current environment, some of those issues may become much more important either to you and or to the state. So the other question you have to ask yourself when you're evaluating all of this is, do you have a reserve and how much of that reserve is there? So we need to talk a little bit further about audit information requests, IDRs. This part of the game plan, I think, has taken on new meaning given the current environment that we're in, because you're not likely to have an on-site auditor for a while. And those of you who have done a lot of desk audits know that they can get a little bit dicey at times. And you yourself may not be in the office. You don't have the opportunity to walk down the hall if you had a complicated federal transaction and pick someone's brain, or a complicated international transaction and pick someone's brain with respect to how things are going. But so the format of the response becomes very important. I would prefer that everyone respond in writing and keep a log of what you've given people. It makes it a lot easier if in the end that you're going to have to appeal it. It also helps with an explanation. In today's day and age, you're not going to be sitting across from the auditor at an opening conference or at a closing conference. So when you start giving explanations of complicated transactions, it's important. With respect to that, proprietary information is always, or confidential information has always been an issue. How you handle board minutes when you're dealing with them from a distance is tougher. How you handle putting a FIN 48 or a FASB reserve in place is tougher. So also, when you look at it, if you look at a transaction tax audit, the volume of documents itself could be just overwhelming with respect to how much you're going to send out. Do you have the ability to send out huge documents through, it doesn't get caught in somebody's firewall? So,
well, and I think what's important here to, hold on, Marilyn, to keep in mind is that, you know, as Marilyn and I both stated, you have these general guidelines or best practices that we would highly recommend that you still operate in during this time. But with that being said, we are in a different time. And so some of those best practices you're gonna have to tweak given the circumstances. So for example, proprietary information, you know, a lot of clients will say, and we'll recommend that if the department wants to look at their board minutes, they have to travel. You know, we're not going to give those out. A lot of companies don't want the proprietary information or the board minutes being given out, any copies made or anything like that. So if a department wants to look at them, they're going to have to travel there. We're obviously right now, we're not able to do that. And so then the next hurdle becomes, well, then how do you make that information available? Do you make it available at all? And how, you know, and that might depend on how hard the department pushes to see it. And also, if you're going to make it available in a limited capacity, what form is that going to take? Is it going to be maybe for a limited time in a Dropbox where only certain people have access? I'm sure a lot of you are familiar now that departments are, you're getting the encrypted emails, and departments, many departments of revenue are taking the security very seriously and have this encryption, which can be a pain in and of itself when you lose the password or you can't get in. And so that's another issue, is how can the department receive that information? Can they receive it by email? Does it have to be encrypted? Can they obtain or access a Dropbox? A lot of different departments have different restrictions on the way they can receive information. And so you have to be proactive, I believe, in asking them what is going to be the best method to get them this information, because a lot of times their email servers can't receive large emails. And so it might be a Dropbox, it might be encryption, something of that nature. And I think you need to get that all set out up front, especially now with our circumstances. That has to be laid out so everybody's operating under the same set of rules. I mean, I recently had a taxpayer working with the Massachusetts Department of Revenue, and they were getting ready to issue the notice of intent to assess. And we had to say, you know, please send that via email. They weren't going to, and we were already in the middle of COVID. They were going to send it in the mail. And we said, you know, no one's in the offices. And we, you know, depending on how much time you have to respond, you may, if by the time someone gets it, if you don't have someone in your mailroom opening mail, getting that to you, you might run through some of your, you know, the statutory deadline to respond. So you have to like make sure you specifically ask for things to be sent in a way that you can receive it, and make sure you're clear as to how you need to send things to the department so that they can receive it, so that you don't blow any deadlines.
So we need to talk a little bit about the internal management of audit and best practices. I think we all do this, but I think it's much more important now because your entire audit team is most likely not in the same spot. I think you need to set expectations and align goals of the audit team. I mean, you may have a number of audits going on at the same time. You should have a general set of goals and what your expectations are on the audits and how you want to handle them. Boundaries of the audit, that goes back to the general practices. You kind of need to know what, you know, how far, what's the scope? What are your general policies with respect to certain IDRs and things like that? And what's your desired outcome? In the current environment, are you willing just to drive the audit assessment down to the lowest point and pay it? Or is there an issue that's going to come up that's going to be an ongoing issue and you need really to challenge it? Checklists in this day and age, electronic ones in particular, are key, because that we're all sharing information with each other internally, and it's very important to understand what's going on. So I'm a big believer in checklists and to-do lists. Depending upon how you want to manage your audits, having a timeline for start to finish is helpful. Now, sometimes the auditor's not as cooperative with that, but the key, in the current environment, things need to be managed a little more closely, I think, than maybe if you were sitting in the office. And you got to continually stay on top of what's going on. You have to realize that if it's an issue that's going to expand beyond one state, that you need to continually track where it's going in the various states and analyze it and make a determination as to whether or not one state's approach is going to hurt you or help you with respect to how you're doing things. I don't think either Breen or I could say enough about communication in this environment is the total key to everything. You can't say more. It's always important, but it's very important now to communicate with your team, to communicate with management, where you are, update on things, what questions, what issues, what risks are evolving out of the audit. The worst thing that can happen to you in-house is no surprises. That was always my motto, no surprises. And a timeline for management as to what you think, how things are going to shake out and what you think is going to come to an end, when the audit's going to come to an end, what the outcome of that audit may be. But having said all of that, we all are living in COVID-19 territory, and we need obviously to somewhat be sensitive to people's environment around them and what's going on with COVID. So with that, what happens on a stalled audit? Basically, I think, and Breen can chime in here in a minute, that I think we're going to see more stalled audits. I think some of the departments that I have spoken with, while auditors are usually pretty good working remotely, not everybody else in the department is good with working remotely, and they don't always have the tools to do it. And so as a result of that, I think you're going to see potentially more stalled audits, because if in fact the auditor is asking for guidance from, say, a technical assistance guidance or something like that, that it's likely to be a longer response time than what maybe would have happened in a normal environment. So you've got to have a policy, I think, that you should have all along about what do you do with a stalled audit. I mean, in some cases, we all cheer when the audit's stalled because we know there's an issue, and the longer we can put it off, the better off we are. The question is, how long are you willing to put that off? You should have a general policy over items like that. And in the current environment, again, being sensitive to what we're living in. But
I think, Marilyn, I'll have to interject here and say that I think that you have to be sensitive to what your policy is right now, and that I would recommend being more proactive under our current circumstances with stalled audits, because very rare, if ever, do we get a situation where an auditor blows a statute of limitation, right? What happens is they swing in at the last second and ask for a waiver. Unless it's an issue that you're trying to push off. If you want to keep things going in the current environment, I think that we're going to be encountering stalled audits more and more often, and it might be incumbent upon the taxpayer to check in with the department to see where the status is. Alternatively, we have clients that have seen auditors become very aggressive right now, and for information that maybe is not at the top of the taxpayer's priority list given the circumstances, and they're pushing for documents, they're pushing for records, and they're trying to push things along fairly fast. And the client is saying, well, what do we do? And I think if you have a plan in place for that now, again, going back to that best practices, then you can easily go there and this is our game plan for a situation like this. And all of this is changing every day because of the circumstances we're in. And I think that, again, also, releasing, when we're talking about reserves for the audit period, releasing anything, I think, again, given our circumstances, would be an aggressive move.
So part of the audit game plan is managing statute of limitations. And it goes without saying, you always need to be sensitive to expiration dates. Either the statute's going to run for an assessment and the notice shows up the day the statute runs. It's also very important with respect to protest periods and things like that. There was a very recent Mississippi case where someone missed the protest period by a day. Apparently they couldn't count 60 when a month had 31 days in it. And as a result of that, it got all the way up to I think it was at the appellate court in Mississippi, and they didn't have jurisdiction because statute of limitations are jurisdictional. But I think there's even more importance to the statute of limitations now, because we can all pick up a book and say it's 3 years, 4 years, whatever it is, or you have 60 days, 90 days. But as a result of the COVID-19 responses, there's been a number of executive orders that have either suspended the statute of limitations. New York suspended the statute of limitations for everything. Not only tax, but all civil suits, all whatever, anything than the speedy trial rule on the criminal side. So there's executive orders out there that you need to be aware of. California has a very broad order that was put out by Governor Gavin Newsom. And it was that the FTB basically had emergency powers to do what it needed. The FTB then extended the statute for anything that was going to, any statute that was going to expire, I think from March 21st through July 15th, that it would not expire before July 15th. Well, that's great if you're a taxpayer and you miss something and you had the ability to file an amended return, but it also applies to the Franchise Tax Board with respect to issuing notices of proposed assessment. So if you thought you were going to have a statute expire April 15th, they now have until July 15th to issue a timely notice. So issues like that are going to be important, and there's going to be some traps for the unwary with respect to statutes of limitations. There's also been it would be easy if it were just all issued by departments of revenue. It isn't. There have been a number of state court orders. The New Jersey Supreme Court issued a blanket order extending statutory periods for filing. So that applies to the New Jersey Tax Court and the timing of that. Similarly, the South Carolina Supreme Court issued a similar order, but the chief administrative law judge seems to be not really doing his own thing. That he is still setting deadlines that are within the old statute. You need to figure out if you have state waivers out there and what it means. You also need to know whether you have federal waivers out there. And in most states on the income tax side, if you have a federal waiver, there are a number of states that you're also extended for the state purposes for everything. California extended 6 months after the federal waiver expires. You need to look to see whether you have special waivers. There are special waivers on the federal side where you may only be holding open a specific issue. A number of states will assume that that's for everything and will say the statute is open for everything. There's also some interesting issues with federal waivers. One comes to mind that there was a hurricane in Houston about a year ago, a little longer than that. And as a result of that, the service extended the filing deadlines for returns. The question is, what does that do with respect to the filing deadlines? And there's an extension of a couple of months that impact the way the federal waivers work. So there's issues like these kind of one-off issues like that that are going to make statute of limitation issues, I think, much more prevalent than they have been in the past. We have another polling question. If I can find it. Okay. As I indicated in the beginning, the polling questions, the polling function in this thing is weird. Well, we may skip the polling question. Oh, there we go. All right. We have found the polling question. Question 2, have you managed a state tax case from audit through litigation? Yes, and we successfully litigated it. Yes, and we successfully settled it. No, we don't litigate our state tax cases. All right, looks like we're pretty much finished. So let's share those results. Looks like we've had 19% successfully litigated a case. That's great. The 35% that have successfully settled it, congratulations. Those are, I think settlements are going to become more difficult in our current environment. The last group that you don't litigate state tax cases, you may be changing your policy with respect to that given the current environment. But so I think we have a question, Bree.
Let's see.
We have a couple.
You didn't have an answer, litigate and lost.
Well, we don't want to bring up bad times, you know, with respect to, nobody wants to talk about their losses. I mean, we have a partner that merely says every time he loses, he didn't lose, the judge just got it wrong. But we don't really want to go that route. But we're now in the post-assessment period. And so how we handle that. Breen, do you want to talk about that? Or you want me to?
So the note, receiving the notice of assessment, you know, obviously we all know that the notice in most, if not all states, establishes the department's prima facie, or the department's case is considered prima facie correct, both to the basis and the amount of the assessment, which mostly to the taxpayers are frustration in most cases. And the taxpayer does have the burden to then establish or plead that whether that the department's assessment is incorrect, even if it is based on erroneous facts. You know, generally what happens is you're going to file, whether you're in the tribunal or you're going to file a complaint, and you're going to plead your facts. And this is when, you know, you can have the option, which we'll talk about later, of raising a TABOR, a taxpayer bill of rights argument, if you're in a state or jurisdiction that has a TABOR, because, you know, usually one of those is that the taxpayer has the right to know the basis for the assessment. And when that basis is incorrect, you know, you as a taxpayer can properly allege that you did not have the basis, or you can allege that the department's basis was incorrect. You can plead the correct facts, and then effectively or essentially flip the burden back to the department, which happens more often than not. where you have department, the auditor, depending on the level of discovery, so to speak, that happened at the audit level, whether the auditor actually reviewed the documents that you gave them. I'm currently working in one that's at the tribunal here in Illinois, and the audit file was over 6,000 pages. And we had already filed the petition in the tribunal, and they responded that part of the department's answer was giving us the audit file. And when I combed through the audit file, I was actually pulling out emails from the auditor to the audit supervisor, and also parts of the audit work papers, the auditor's notes and write-up that was citing to the correct information, yet when they wrote up the actual assessment, they didn't use any of that. And so, the path that we did is that instead of engaging in prior to engaging in what could end up being costly discovery process, we drafted a lengthy response letter to the audit file, highlighting and pointing out what was incorrect, what the correct facts were, and what the erroneous facts were the department either made up or just relied on incorrectly. And we said, okay, given this, do you want to reconsider your position? Do you want to reconsider this notice? So again, this is an avenue that you could take prior to getting to that costly discovery process. Particularly if you're dealing with a matter that might have a pretty in-depth or long audit file where a lot of the information might already be there, you could potentially, avoid that. So that is one of the options. Again, when you're going to best practices, that might be something you consider, kind of pulling, again, that concept of settlement. Something we'll talk about later is there is really the ability to settle at any level, or that is something that we subscribe to. And just because you filed the petition in court or at the tax court, or you filed a complaint in circuit court, doesn't mean that you have now cut off the ability to settle. A lot of times there might even be, a lot of times the opportunity presents itself after discovery or after a situation like this, because more information has come to light, and it might be enough to get the department to reconsider their position.
I think one of the things that you've not seen a lot of litigation on, but it's key to the taxpayer's burden to establish by competent evidence whether the assessment's correct. In the income tax world, you have a number of states that have chosen after the audit to adjust your apportionment factors and argue that it's some version of alternative apportionment. The burden to raise an alternative apportionment question is on the party who's raising it. But there's a conflict between that and an assessment that's deemed prima facie correct. So if in fact they have changed your apportionment factor or taken a position that gain should be thrown out or something shouldn't be put in the sales factor, I think there's a real question as to whether or not it's your burden at that point to show that the alternative apportionment was accurate or more reasonable than what if you followed the statutory apportionment. Those are kind of cases I think you're going to see come out more as a result of what's been going on with more aggressive audits in that area, but also there is a conflict between the taxpayer's burden and who has the burden when you argue alternative apportionment. So another issue to be aware of.
So when you're dealing with the post-assessment, obviously the options that you always have, you concede and pay the assessment. I think that, as Marilyn alluded to a little bit ago, I think that we are going to see a lot less of that happening. If what happened in 2008 is any indication, you see a lot of companies having less cash flow, or really right now cash is king and you're wanting to hold on to it as much as you can. And so you see taxpayers willing to or wanting to fight some assessments that maybe during good years they would have just paid to not have to deal with. You can pay and file a refund claim, pay and then live to fight another day, buy yourself some time. You can prepare and file a timely protest. Again, under the certain circumstances, be very aware and cautious of the filing deadlines, the timing requirements on that. Make sure you know how you're going to receive it. Again, going back to what I said earlier, just if you're going to know, especially on audit, when the audit's over and when they're going to be preparing to issue that notice, make sure you are on the same page with the auditor that they are going to issue it electronically. If they have to get special permission to do so, ask them to get that. I know a lot of states are prohibited from issuing it electronically, but I will say that I have had states get special permission to do that right now. I've had clients that have received them electronically. What they do is they have to put like draft language on the notice, the one that they issue you electronically, and then they still mail a hard copy, but they will email it to you. Different states might just have different protocol as to actually how to do that. So again, given COVID right now, just be proactive in that, because I can guarantee you, if you're not, they're not going to be as willing to work with you when that deadline has lapsed. Now, obviously, there's usually options like a discretionary hearing request and so forth that you can still have your day in court if you wanted it, but just leaving it unsaid, I think right now is not a good course of action. I think I am a huge proponent of being very proactive and vocal and transparent when dealing with the departments right now, as far when you're getting to the finalization of an audit. And then you have to decide what route are you going to take, depending on the jurisdiction. Do you still have the administrative review level? Do they have a tax court? Or if you're in a state that you can pay under protest, are you going to pay under protest and go straight to circuit court? Again, right now, given our circumstances, using 08 as kind of a guide, I would say a lot of taxpayers are, they would prefer not to pay. They don't want to be out of pocket a lot of that. So if there is an administrative route, or if there is a tax court in your particular jurisdiction, that's usually the preferred method.
I just recently, to Breen's point about figure out how you want something delivered to you and if they'll do it electronically, we had an informal conference with the state of Michigan in February or late January, early February. And I was following up as to where the decision was, and emailing the hearing officer, or the individual who held the informal conference. I was told, well, the decision was mailed to you, the preliminary decision was mailed to you on the 22nd of April. And this was about the middle of May. And I knew that there's going to be, if we'd lost, which fortunately we didn't, but if we lost or didn't like the result, there's a time period in which you could appeal it. As we sit here right now, I have yet to receive what theoretically was put in the mail on the 22nd of April. They did ultimately email it to us. We were successful in convincing them during the course of this informal conference that we were correct. So we didn't run up against the deadline of having to file a protest to the next level in Michigan, but to the tribunal. But real life experience, and mail is being totally delayed. And so there's going to be some time, there's time sensitive documents, and there's going to be some issues with respect to that. So we're going to talk a little bit about resolution methods and best practices. I can't stress enough. I mean, every company before we went into this, or every group of people before we went into this, probably had a pretty good game plan of how they want to handle audits. If it's above X value, we're going to challenge it. Or if it has a specific issue that's going to extend to a number of states, we're going to challenge it. Or just on principle, we have certain issues that we're going to challenge. Some of those initial decisions may be changed because, as Breen says, cash is king. And in the current environment, I think it's going to be more difficult to settle things. And so, or
and I think a lot of companies' materiality threshold is going to be changing as well.
Yeah. So I think you need to know internally, sit down with both your internal audit team and management as to what your ultimate goal is with respect to the assessments or audits in general. And you need to have open communication with management. As I said, the worst thing that can happen to you as an in-house attorney or audit supervisor is as a surprise, particularly in this day and age where everyone is managing cash flow. Cash out the door is not a surprise that anyone needs. The question, though, is one of the questions I think you have to ask yourself, and it's generally based on the issues that you're seeing, is when do you need outside advisors? And if you do, when you get them involved? And that goes back to what were your initial strategy and goals. If you know that you've had a complicated restructuring, or you've had an acquisition or a disposition, and you know it's going to pop issues, then maybe you get your outside advisors involved sooner because you need reserve memos, or you need to develop a game plan much earlier on as to how you want to handle the audit and what information you're going to give and how that information is going to be delivered. Depending upon the issues, there's a number of states right now that are pushing 482 type issues. Unique version of 482, I might add as well, but 482 type issues. If you know that you're going to be faced with one of those issues, you should get your advisors in early on. You're going to need someone to do a 482 type analysis unless you have one of those already built in-house. When you go to hire an outside advisor, that may be more than one. And the question is, what advisor hires the other advisor? There's privilege issues with respect to, if you know you're going to, 482 is a good example. If you know you're going to push this further and you need a study, you may want a law firm to hire the accounting firm or whoever's doing the evaluation study for you. So you have some privilege and going forward. Those are the kind of issues that you need to evaluate early on as you start to evaluate what your resolution ideas are going to be. There's some options that you can do. You could go in during the course of the audit and ask for tech advice if you think the auditor is applying a statute or applying rulings inconsistently or inconsistent with the way the regulations or the statute read. So tech advice is one approach. It can take the form of a private letter ruling, but generally letter rulings, you can't pursue those if in fact you're under audit in most cases. You can request an informal conference I would suggest above the audit and the audit supervisor level, because if you're not getting anywhere with the auditor, the next level up is not going to help. But there are a number of states that provide for the ability to have an informal conference. I'm going to do something in 2 weeks that I have an informal conference with the state of Alaska, and I've had a number of those in my career, but I've never had one virtually. We've always done them in person. So I think when we talk about the new world, we have to realize that some of these conferences are going to be done. This one's going to be happy to be done by a Cisco WebEx, but by Zoom or Cisco WebExes. And does that change how you approach the conference? Does that change how you make your presentation? It's harder to exchange documents that way. Everything needs to be in the other party's hands. There is such an ability in both of those to share screens, and that may be one approach to it. But it takes some more planning than it does when you're sitting across the table for someone. Settlement authority, having gone through that in a prior life a lot, what is your settlement authority? What's the company's appetite for settlement? Who has to give you that authority? What are their authority limits? Every corporation has authority limits. Can the VP give you that authority, or does it have to go higher than that, depending upon the value of it? There are a number of states, and we're going to talk about them a little bit more, but where you can have sort of an arbitration/mediation. Massachusetts comes to mind, and we'll talk a little bit about Mass towards the end of this presentation. Will the department participate in something along those lines? Or I've been doing this a long time. I don't think I've ever seen a court-ordered mediation in a tax case. It certainly happens in a lot of other civil litigation, but it doesn't. I have never been involved in one in a tax case. I have used a mediation group out of California to sit down and kind of hear both sides and make a determination as to whether or not we were going to be successful with what at that point was a boiler fuel case. Or are you just going to go litigate? I mean, it's the issue is such that it's black and white. You need to litigate it because it's going to extend to other states. It's a significant amount of money. You need to make a determination, but you have to evaluate all of your options. And I suggest that you make that evaluation and present that evaluation to management or whoever is the ultimate decision maker with respect to all of that.
Really quick, just to interject something that, Marilyn and I advise a lot of our clients when we're in a situation like, we, over the last couple of years, she and I have had a lot of matters at the California Settlement Bureau. And it's, do you want, it's kind of an interplay with settlement authority and meeting with your advisors. One, is there a point in the process where maybe if you meet with your advisor or get them involved early, can they reach out to someone, say above audit, like Marilyn said? So like, let's use Illinois. We're in Illinois right now. Can a call to FLEAFLET potentially clean up this matter fairly quick for you? Or now jumping over to the settlement, the interplay between settlement authority and meetings with your advisors. Sometimes, do you as the client want to be there in person? And again, this may change, this is going to change now under the circumstances we're dealing with if we're going to have meetings with the department over Zoom. But before, when we were having these in-person meetings, do you want someone at the meeting who has settlement authority? Sometimes strategically, it's better to have your advisors go there, because if if you can reach, or we can reach a settlement in principle, we always have the fallback that, well, we don't have settlement authority, we have to go back to the client, or be on the same page. What are your anchor points? What are things you're unwilling to give up? And when are you going to walk away? And what are the points at which you say, okay, my settlement authority only goes to X, we're going to have to circle back. And then that way you're not cornering yourself into having to make a decision at the table right there.
I think it's also important, depending upon who you take to the meeting, if in fact it is a significant issue, sometimes the higher up the chain of command in the tax department, the better. It's rare that you see a VP of tax show up at a state tax informal conference. But if in fact it is a significant issue and it's important to the company, or it has a significant amount of penalties attached to it, you may want to play that card just to show how strong you feel about it, and as a way to show that you're dead serious about what's going to happen. I think
strategically things to take into consideration.
I think another strategic thing to take into consideration is to know what kind of forum you're going into. Is your forum start out internal or is it external? If it's internal, do you have to make a record of that? And that's key. If you're at a tax tribunal or administrative hearings, and that's where you have to make your record, that becomes serious. That's like being in the circuit court or a superior court. And so evidence has to go in, depositions have to be taken. We're talking about discovery a little bit. You have to build your record, because at the next level, you may not have that opportunity, or you will not have that opportunity if it's not a de novo review. So you really have to understand what type of system you are in and where you're making your record and how important it is at that level to make your record. You also have to be careful at an internal system that's an informal conference, that what you say and how you present it doesn't come back, so to speak, to bite you later in an external hearing. So it's a fine line, but you need to understand where you're at and what the ground rules are in those both forums. If you move out and you've lost at the informal level, you're lost at the department level, now you want to move on, do you have to pay the tax to move on? In the current environment, that may be cash is king, and we're all doing cash forecasting. That may be very important in the current environment. Discovery rules are important. Is discovery allowed? Is discovery not allowed? Can you take depositions and things like that? That's all for building your record. If you are required to build a record at like an Office of Administrative Hearings, an OAH, or in California, you don't have to do it at the OTA in California, but in Illinois, you have to do it at the tribunal, or in Cook County, you have to do it at OAH, Alaska, you have to do it at OAH. It's important to know what the discovery rules are, and are they available to you? Equally important is to know how much public access there is to the proceedings or the decisions or the taxpayer record. We all know that tax records are generally confidential. And when you're still in the Department of Revenue, they're confidential, and there's statutes that govern that. Once you get out of that, you need to be careful as to what records are available to the public. You can get protective orders. In some states, that's easier than others. But you just need to be aware of that fact. It's also key to understand that if there's any precedent against you, you may want to take a step back and reevaluate your case, and or kind of reevaluate how you're going to argue your case if in fact it's going to go forward to it. But key to understanding the forum is a major part of the ball game at this point. You want to talk about settlements?
So yeah, as we've mentioned numerous times during the presentation, an opportunity to settle is almost always available, regardless of where you're at in the process. For me, what I think for both of us, I will speak for Marilyn, she could chime in, but I think one of the key pieces that we will always evaluate in conjunction with our client is there a go forward issue, right? So how difficult is a settlement going to be to obtain? Sometimes will hinge on whether or not this is a go forward issue. If this issue is moot after this audit cycle, you're going to see the department's going to be more willing to reach a settlement with you. When a lot of times when you have to address go forward concerns, that's where it could get a little bit more complicated. Or you can carve issues out. You know, again, we talked about earlier, do you have chips that you want to use? Meaning, again, this goes back to best practices early in the audit. Identify those issues that you might consider, depending on the company, you might consider a throwaway issue. You might call it a throwaway issue. You'd be willing to concede in order to get the material items that you're looking for. How willing is the department to address go forward issues and willing to settle or come to an agreement on those, and for how long, right? You know, how many years going forward are they willing to agree to a certain position? Again, during these times, I think some companies are going to be more prone to litigating and protesting assessments that come up because, again, there's going to be less cash available, less liquidity for a lot of taxpayers. So settlement, the ability to settle regardless of where you are in the process may be fairly attractive to them. The resolution, and I think I've really kind of already talked about this, evaluate the strength of your positions. Know what your streams of revenue are, be able to document those, be aware of your facts. What documentations do you have to prove up what you're looking to settle for, and understand where your weak points are. If you have a good grasp on all of those, it makes settlement easier. It makes the ability to get there a little smoother. Also, know who to negotiate with. Sometimes, very rarely are you going to be able to get the auditors to agree to anything as far as settlement goes. I've reached settlement, or I've reached resolution, if you will, at the audit level, but that was not without having to reach out to someone higher up. So again, if you're in Illinois, you're reaching out to someone like Roger Cost to try to help you with that audit. And then if you are entering into a settlement, consider the impacts it could have on other states and other audits. If this is an issue you're litigating across the country, if you're litigating if you have a unitary issue or a business, non-business, those are something very common. If you've had a large divestiture over the last couple of years, you might have multiple states looking at that. And are the departments going to share that? Are they going to share information? A lot of times, we push for confidentiality, but nowadays that's very rare to get a department to agree to. One huge piece of advice is don't be afraid to revise. And this kind of goes into the next slide with settlement documentation. Don't be afraid to revise standard forms. We always offer right off the bat to draft the settlement offer, or we'll make the settlement offer, or if we reach a verbal agreement, we will offer to draft that agreement. If the departments draft it, you are going to get a standard form that maybe they use for everything and they fill in the blanks. Do not be nervous or scared to revise that. You have the ability, again, this is all a negotiation. You have the ability to change that language. Even if they object to it, do it, throw it in there, see what you can get from them. Again, this goes to confidentiality. We know 9 times out of 10 that's going to be thrown out. We still will always go for it. The agreement should address the issues settled. The methodology you use, do you have to include schedules? A lot of times we will throw the schedule in there. So there is no misunderstanding as to what the numbers should look like. What is the impact on future periods and audits? So we've had agreements where we come up with a methodology and the department is prohibited from auditing the taxpayer that on any years that are covered by this agreement. We've had departments still try to. So, you know, make sure you have that saved somewhere where you know where it's at, or your counsel does, so that you can easily cite to that. Again, what's the impact? You have to look at this holistically. Is this going to impact future years? We've had situations where we've settled earlier years and the client had already filed their returns for future years, and they had to file amended returns because the settlement we were able to reach affected NOLs that they use in later years. So what is going to be, you need to make sure you have that all planned out and you know the ramifications, not just in the audit years you're dealing with, but also for future years. Impacts on other members of the group, potentially that could happen. State information sharing. Again, this is why departments generally won't agree to confidentiality. And then also you always have that blanket language in there that this settlement is not admitting to anything, because you don't want this used against you in say in a future year. If you've changed the position, if your group has changed, because again, facts change, right? If say you're dealing with a unitary issue and your group has changed, you don't want something you agreed to in the settlement offer to potentially be used against you in future litigation.
One caveat to this, and then we'll move on. I think we have a question. Is we have all these settlement agreements and you try to keep them confidential. What's been interesting is there's been a number of FOIA requests with the city of Chicago asking for all settlement agreements that were entered into when the city changed its position in the personal property lease transaction tax in 2015, where they had a voluntary disclosure program. So while you try to keep things confidential, the use of FOIA has become very prevalent, and this had to be done by a state tax or publication that was asking for it. But so you need that's lurking out there. So while you try to keep everything confidential, it may not always work that way.
So our question was whether or not we've ever used politics to settle. Government is business friendly, but the department is hitting with huge assessments. And the answer to that is yes. So we have had multiple experiences. Marilyn and I had a couple just within the last few years, one being in Utah. We had a client, and one in New Mexico, two different clients, but one of our clients had its North American headquarters in Utah, and they received a very large assessment in Utah. And so they hired, and we worked in conjunction with government. They weren't lobbyists, but a consulting agency where they were trying to negotiate a deal with the Department of Revenue based on the client's presence in the state. And we also had a situation where, and that one was successful in that we were able to, that aided in the resolution of the matter. The one in New Mexico, they attempted to do it politically by promising to bring more industry, build more in the state. But at the time, those in power in New Mexico were not receptive to it. But interestingly enough, we ended up being able to resolve that one. We ended up reaching a very favorable settlement with the department on they ended up agreeing to our client using.
So we only have like about a minute left. And I will tell you, Brina and I, neither of us are lobbyists, and there's certainly, if you're going to go in and enter into economic development agreements, there's certainly ways to resolve things. There are a number of non-traditional methods that we're going to go through very quickly. I would urge you to check the Taxpayer Bill of Rights. I would look for any administrative guidance that's out there, both public and you can get under a FOIA request, non. There are alternative disputes resolutions and type of administrative guidance that's out there. These are the key programs. There's settlement programs both in California, which I think works well. The Massachusetts mediation program, we've used that a number of times in our office. And the MTC has an alternative dispute resolution program that I have never used, but I know people who have, and it has been relatively successful. And I think we may be out of time, but we have.
Sorry, I lost my connection.
We have one last polling question. Let's see if I can actually pull this off. And let's, last polling question is, Have you, so our last polling question is, have you utilized the non-traditional resolution method? We have used alternative dispute resolution. We have used a formal settlement process. Yes, we have sought private letter rulings. No, we have not pursued any non-traditional approaches.
We should have one that says, yes, we've done all of the above, because we definitely have clients that have done the first three.
Right. So with that, looks like about 38% have not used any non-traditional. Private letter rulings are obviously been used a number of times. Formal settlement in private letter rulings came in as a tie. So that formal settlement processes seem to work well. And there's also alternative dispute resolution, which is catching on more than it has been. Well, with that, I think we are probably over our time. We both thank you very much. If you have any questions, you can email either one of us or just into general, and we will be happy to respond to them. So
thank you, everyone.
Thank you, everyone, for your time.